based on validity and formation is done. Execution we have to discuss. Daivik, stand up. Pre-consent is missing. Contract becomes valid, void or voidable. Pre-consent is missing. Pre-consent is not there. Contract becomes valid, void or voidable. Pre-consent is not there. Contract becomes valid, void or voidable. Santosh, come here. Free consent is not there, contract becomes valid, void or voidable. Voidable. Whenever consent is not free, contract becomes voidable. Voidable means aggrieved party can avoid the contract. The party who has suffered the loss can go to the court, can file a case in the court of law and can put an end to the contract. Right? Mir kucho. At last. Good name? కొంచెం టైం పడుతుంది నాన్న. ఐఎమ్ గజ్ని టైప్, నాకు వెంటనే గుర్తుండదు పేరు. సరేనా? రిషిత తప్ప ఏం గుర్తులేదు. సో initially it's a valid contract only, but due to future impossibility it becomes invalid. Such contract is a valid contract or void contract or voidable contract. Void contract. Void contract is one which is valid initially, but sorry. So pre-consent is not there means contract becomes voidable. Okay, when a contract is initially valid but becomes invalid due to future impossibility or supervening impossibility, it becomes a void contract. When a contract, stand up. When a contract satisfies all the essential elements of a valid contract, it becomes valid, void or voidable. Valid. A contract which satisfies all the essential elements of a valid contract becomes a valid contract. Charanya. What is a quasi-contract? Created by law. A contract which is created by law is a quasi-contract. Any example can you give for quasi-contracts? Valid example only we have discussed, no? Sit down. You. What is a... No, sit down. I'll ask someone else. Last bench. Your good name? Tulasi. What is a implied contract? We have discussed about express contracts and implied contracts. No? What is an implied contract? Yes? Contract done by behavior. Correct. See, a contract entered between the parties without any words spoken, without any written agreements, by the conduct of the parties, by behavior of the parties, is known as implied contract. Tacit contract means what? You sit down now. Tacit contract is a express contract or implied contract? Implied contract. Sit down. Quasi contract is also an implied contract. Tacit contract is also an implied contract. When a contract is created by law, it is a quasi contract, and when a contract is created by fact, it is a tacit contract. Tacit means silent. What else we have discussed? Who else? What's your name? Anushka. You said so many times. That is the reason only I said I am Gajni type. It will take time for me. So, what is the express contract? Okay, contract entered by word spoken or by written agreements is a express contract. Sit down. These are the contracts based on validity and formation, right? Santosh, what is an illegal agreement? Illegal agreement means an agreement in which consideration or object is unlawful or illegal, right? Sit down. Is this not working or what? Wait. Oh, not a problem. I have to connect this, no? I forgot. I saw the overheating text, no? So I wanted to restart it once again. If anything happens means... it will not blast for sure. Coming to contracts based on execution, right? Yes, sir. What are the contracts based on execution? First point. Executed. I'll give you an example. Your name? Vaishnavi. Vaishnavi agreed to sell a car to me for 50 lakh rupees. Vaishnavi agreed to sell a car to Gautam for 50 lakh rupees. Who are the parties to the contract? Vaishnavi and? Who is giving offer? Who is accepting? Who is the offerer? Who is the acceptor? So, Vaishnavi delivered the car. Gautam paid consideration. Here, only one party performed his obligation or both the parties performed their obligation? Both the parties performed their duties or obligations. Yes or no? I delivered the car, my job is done. She paid the money, her job is also done. Both the parties performed their obligation. Both the parties received consideration or not? Yes or no? So, when both the parties received consideration, contract comes to an end or not? When two parties received consideration in a contract, it is known as executed contract. What is an executed contract? When two parties received consideration in a contract, it is known as executed contract. Write down. Yesterday only wrote, no? What is the next point given here? Executory contract. The same example I will take. I agreed to sell my car to Vaishnavi for 50 lakh rupees. I delivered the car. Vaishnavi promises to pay the money after 1 year. Who did performance and who did promise? Gautam delivered the car. Vaishnavi promised to pay the money after 1 year. Who did performance and who made a promise? Who received consideration? Who have not received consideration? Vaishnavi received. Gautam has not received any. If one party only received consideration, it is known as a executory contract. When both the parties received consideration in a contract, it is known as executed, completed. Executed means completed. When two parties in a contract received consideration, it is executed contract. When only one party received consideration in a contract, it is executory contract. No confusion. Next point. What is it? Unilateral contract. Means what? In a contract, my dear students, when only one party is known and the other party is unknown. Only one party is known and other party is unknown. Such type of contracts are known as unilateral contracts. Let me give you an example, you will understand. Gautam walking on a roadside with his nephew, a small kid. Suddenly, the kid is missing. The kid is missing. Gautam searched for him, unable to find that particular kid. So what he did, he gave a newspaper advertisement. Whoever finds my nephew will get a reward of 50,000 rupees. Who is giving the offer? Who is the acceptor? Whoever finds the kid becomes the acceptor. Yes or no? Offerer is known, acceptor is unknown at the time of entering into the contract. Yes or no? Such type of contracts are known as unilateral contracts. Only one party is known and the other party is unknown at the time of entering into the contract. Such type of contracts are known as unilateral contracts. Types of offer we'll discuss. Okay, don't relate types of offers with types of contracts. Fine. What's wrong? So what is the next type of contract? Bilateral. What is a bilateral contract? Bi means two. When performance from both the parties is pending, it is known as bilateral contract. When two parties in a contract have not received any consideration, it is known as a bilateral contract. When only one party received consideration, it is executed or executory. One party received consideration means two parties received consideration means both the parties have not received consideration means bilateral. One party is known and the other party is unknown. This is what is the difference? These are the contracts based on execution. Three types of contracts. Contracts based on validity, contracts based on formation and contracts based on execution. No confusion? Shall we move to the next topic? What is the next topic? Differences between void and voidable contract. Read the definition. Meaning. Means what? Initially it is valid only. When its validity cancelled at a future date, it becomes invalid or void. To cease means to cancel. To cease means to cancel. Next, voidable. A voidable contract is one which is enforceable by one party in a contract but not by the other party in a contract. Gautam threatened Santosh with a gun and asked for his mobile. Who is committing default? Who is threatening? Whom? Santosh. For getting acceptance from Santosh. Yes or no? Consent is free or not? Who can go to the court? Who can enforce the contract in the court of law? Who cannot enforce the contract in the course of law? So, a contract which is enforceable by only one party but not by the other party, it is known as a voidable contract. Who can enforce? Aggrieved party can enforce the contract or defaulting party can enforce? To enforce means to go to the court and to file a case. Now say, aggrieved party can enforce the contract or defaulting party can enforce the contract? Defaulting means a party who has committed mistake. I threatened you. Can I go to the court and file a case against you? Who can go? You can go. You are not a defaulting party. You are the aggrieved party. I am the defaulting party. In a voidable contract, when one party forcefully obtains the consent of the other party, free consent is missing. The person who is forcing is the defaulting party. The other party who is suffering the loss is the aggrieved party. Who can cancel the contract? Defaulting party or aggrieved party? So the contract is enforceable by defaulting party or aggrieved party? Is that clear? Voidable contract is a contract in which only one party can enforce the contract, other party cannot enforce the contract. Aggrieved party can enforce the contract or cannot enforce the contract? Defaulting party can enforce the contract or cannot enforce the contract? Gautam threatening Santosh. Who is the aggrieved party and who is the defaulting party? Gautam is threatening Santosh with a gun. Who is the defaulting party? Who is the aggrieved party? You have to know the difference between defaulting party and aggrieved party. Only aggrieved party can go to the court and file a case in the court of law. Means what? Aggrieved party, at the option of the aggrieved party, the contract is enforceable. At the option of the defaulting party, contract is not enforceable. A contract which is enforceable at the option of only one party but not at the option of the other party is known as a voidable contract. Contract becomes voidable whenever consent is not free. Contract becomes voidable whenever consent is not free. Clear? Second point. Read. Contract becomes void due to the change in law or change in circumstances beyond the contemplation of parties. A valid contract becomes void at a future date due to change of law sometimes. I will explain with an example. Gautam agreed to sell a piece of land to Vaishnavi. Gautam agreed to sell a piece of land to Vaishnavi for 50 lakh rupees. After entering into the agreement, valid contract or not? Two parties are entering into a contract, both the parties are having consideration, lawful object is there, lawful consideration is there, satisfying all the essential elements of a valid contract. I am agreeing to sell my own piece of land to Vaishnavi for 50 lakh rupees. Okay, after entering into the contract, government acquired the land for a particular project. Can I sell the land now? Law changed or not? According to the government, change of law made the contract, valid contract, void or not? This is what? A valid contract becoming void at a future date due to change in law. No confusion? Another example I will take. Gautam, an Indian, imports raw material from China. Imports raw material from China for mobile manufacturing. Gautam is having a mobile manufacturing unit. Gautam imports raw material from China for manufacturing mobiles. After entering into a contract with China for importing raw materials, India declared war against China and clearly said no Indian citizen is supposed to enter into a contract with China. Valid contract initially before the declaration of war becomes void or not after declaration of war because law changed in the country. Due to change of law, a valid contract initially becomes a void contract at a future date. Next point. Contract itself is void, invalid. Performance is needed or not? When a contract becomes invalid or void, parties will perform or not perform? Parties will not perform because contract is invalid or void. Yes or no? Next is voidable. Read. I'll explain. Gautam threatened Santosh to get his iPhone for 5,000 rupees. Okay, in fear, Santosh sold the iPhone for 5,000 rupees only to Gautam. Who is the defaulting party? Who is the aggrieved party? Who can go to the court and file a case in the court of law? Immediately, Santosh should go to the court and file a case and take action against me or not. But without doing that, Santosh kept quiet. Such voidable contract becomes valid. I can file a suit against him to get my mobile. The contract becomes enforceable. Who should take an action in a voidable contract? Aggrieved party or defaulting party? When contract becomes voidable, my dear students, aggrieved party immediately should take an action. Aggrieved party should go to the court, should file a case in the court of law, should put an end to the contract, should ask for restitution of benefits, and should ask for compensation also. If the aggrieved party is not doing all these things, means in an implied manner, aggrieved party is accepting the contract. Aggrieved party is accepting the contract. When aggrieved party is accepting the contract becomes valid or not? That is the meaning. Read the point again, you will understand. Reasonable time. No confusion? Wait. What is the next point? Rights. In a void contract, parties will have any rights or no rights? Contract itself is void, invalid. Parties will get rights or no rights? No rights. In a voidable contract, defaulting party will be having rights or aggrieved party will be having rights? What rights? He can go to the court, he can cancel the contract, he can ask for restitution, restoration of benefits, he can claim for compensation also. Yes or no? Who is having rights? Aggrieved party or defaulting party? Is that clear? Read the provision. Rights point. To rescind means to cancel. To rescind means to cancel. Who can rescind? Who can rescind? Defaulting party or aggrieved party? Aggrieved party means who? Who has suffered loss in a contract is known as aggrieved party. Who is committing default in a contract is known as defaulting party. Aggrieved party will get a right to rescind the contract, to cancel the contract, to put an end to the contract. No confusion? These are the differences between what? Write down. Write down the differences between void and voidable contracts. What? I forgot. Your name. Wait. I'll try to recall. Janvi. Yes or no? Revati, Vaishnavi, Sharanya, right? Sharanya, Vaishnavi, Rishita, and gone. Gaya. Janvi, I know. Tulasi, I know. You, Revati, right? Revati, I know. Remaining names, don't know. Who is Sakshi? Sakshi. And Tanishka. Tanishka or Tanushka? Tanushka. No need, no names required. Only Santosh. That's it. Daivik. Okay. By default, I will remember boys' names, not a problem. Problem is with the girls' names. Fine? Manam okati kada, sir. Rayandi. Santosh, you and me should not change our places. I should sit here, you should sit there. Okay? In my class. She should be sitting in the first bench. She should sit in the first bench only because of her height issues. శరణ్య స్ట్రైట్గా కూర్చుంటే వెనకాల ఎవరు కనిపించారు నాకు. నాట్ శరణ్య, రిషిత. కన్ఫ్యూజన్. రైట్ డౌన్ ప్లీజ్. Stop talking, focus on writing. Your previous batch students, I used to made them to write the whole thing. But for you people, I am giving few exceptions. Feel happy for that. Differentiation questions are, my dear students, very important in the examination point of view. For sure, you have to remember all these basis points. Okay, basis points you are not supposed to change while you are writing. As it is, you have to write. Meaning is given. Instead of meaning, you are not supposed to write definition. You have to write meaning only. Cause is given. You have to write cause only. Fine. Any doubts? Done. Daivik, you are writing in a new notes only, no? Or in a rough book? Why? తీసుకోండి సరేనా? Done? Yes or no? Shall we move to the next topic? Still writing? Done? No? Write down, write down. Make it fast. Can you copy from your friends? Okay? You should say. Moving to the next topic. What is the next topic? Differences between void and illegal agreements. What is the first point? Read the first point. Other point. What is given here? A void agreement is not necessarily illegal. Social and domestic agreement between husband and wife. It is a void agreement or illegal agreement? There is nothing illegal, no? So a void agreement is not necessarily illegal, but an illegal agreement is always void. No confusion? Second point, void agreements are not forbidden by law. Illegal agreements are forbidden by law, against to law. Void agreements are not against to law. Illegal agreements are, legal means according to law. Simple. Illegal means against to law. Right? Next. If you are carrying on some illegal activities means you should take the punishment or not. If the agreement is illegal, parties should take some punishment. Next. Collateral. Read. Agreements. Collateral to continue, no, in the down. Collateral agreements. Next. Read. Read the explanation, ma. It may be valid also. Next. Agreements collateral to void agreements may be valid, but agreements collateral to illegal agreements are always void. What does this mean? To understand this provision, my dear students, you have to understand what a collateral transaction is. Anyone in the class? No? Collateral transaction. What is a collateral transaction? Collateral means connected or secondary. Connected or secondary. Let me give you an example. First we'll take void agreement example. Void agreement example. Gautam asked Santosh to come for a movie. Gautam said to Santosh, Santosh, let us go for a movie. Contract between a teacher and student arising out of natural love and affection. Social and domestic agreement or not? Yes or no? Valid or void? How can you say that a social and domestic agreement is valid? Social agreement is valid or void? Domestic agreement? Illegal agreement? Political agreement? Commercial agreement? Legal agreement? Only commercial and legal agreements are valid. Social and domestic agreements are valid or void? So this agreement between Gautam and Santosh is a valid agreement or void agreement? Valid agreement or void agreement? Void agreement. So Santosh gives his acceptance. Santosh gives his acceptance. Offer is made by Gautam. Santosh accepted the offer. It is a social and domestic agreement. Void in the eyes of law. Clear? As Santosh has given his acceptance, Gautam went to the movie theater to buy 2 tickets. With the theater owner, again Gautam entering into a contract or not? To buy 2 tickets. Gautam will give money. That is the consideration for the theater owner. Theater owner will give 2 tickets to Gautam. That is the consideration for Gautam. This is a commercial agreement or not? Valid or not? But this is the agreement which is connected to the main agreement or not? Main agreement is the agreement between Gautam and Santosh. Gautam entered into an agreement with Santosh to go for a movie. For that purpose, Gautam went to the theater to buy 2 movie tickets. 2 agreements are there or not? The agreement between Gautam and Santosh is the main agreement. The agreement between Gautam and the theater owner for the purpose of going to the movie is the secondary or connected agreement or not? This connected agreement is known as collateral agreement. Collateral agreement. Now here in this case the main agreement is valid or void? Void. Social and domestic agreement and void. The secondary agreement, the collateral agreement is valid or void? Valid. Now read the first point. It may be valid also. Conclusion is agreements connected to the void agreement, agreements secondary to the void agreements may become valid. But agreements connected to the illegal agreement always becomes illegal and void. Illegal and void. I'll take another example. Mr. A hired Gautam to kill Mr. B. Who is hiring? Who is hiring? Mr. A is hiring Mr. Gautam to kill Mr. B. Who is giving the offer? Who is accepting? What is the purpose? To kill B. To kill B. A is hiring Gautam to kill Mr. B. Who is entering into the contract here? A and Gautam. Who is giving offer? Who is accepting? What is the purpose? To kill Mr. B. Legal purpose or illegal purpose? Illegal or legal? Killing Mr. B is illegal. Killing someone, entering into a contract to kill someone is legal or illegal? Illegal agreement or not? Illegal agreement is entered between Gautam and Mr. A. For the purpose of killing Mr. B, Gautam bought a gun from Santosh. Gautam bought a gun from Santosh. This is the second agreement or not? Collateral agreement or not? Main agreement is between Gautam and Mr. A. For the purpose of killing Mr. B, Gautam bought a gun from Santosh. The second agreement is also illegal and void or not? Main agreement is also illegal and void. Secondary or connected agreement is also illegal and void. That is the conclusion. Collateral transaction or agreement to a void agreement may be valid, but collateral agreement to a illegal agreement is always illegal and void. What is collateral? Connected or secondary agreement. Any confusion? Revati, can you explain this point? Yes? Collateral transaction to a void agreement may be valid or always void. Collateral transaction to a void agreement may be valid. It is not always void. But collateral transaction to a illegal agreement is always illegal and void. Is always illegal and void. That is the point you have to remember. Sit down. No confusion, no? Easy only. Start writing. మాట్లాడొద్దు నాన్న, మాట్లాడొద్దు. డోంట్ వేస్ట్ టైం. ఫోకస్ ఆన్ రైటింగ్. Vaishnavi, stand up. For suppose, for your birthday party, you invited all your friends. They agreed to come on your birthday. Okay. For serving food to them, you ordered biryani from Paradise. Here, what is the which one is a void agreement and which one is a valid contract? How many contracts are there in this transaction? You inviting your friends, you giving you an offer to your friends is one agreement. Yes or no? And you ordering biryani from Paradise is the second agreement. Which is void and which is valid? Because it is social and domestic. Ordering food from Paradise is valid because it is legal agreement. Both the parties are having consideration. It is a legal agreement. So, sit down. Which one is the main agreement? Ordering food is the main agreement or inviting friends for birthday party is main agreement? Which one is connected agreement? Ordering food from Paradise is the connected agreement. So, that agreement is the collateral agreement. Fine? అయిపోయిందా? రాయండి. వైష్ణవి రాయట్లే. Contract also can become void, no? Agreements which are not enforceable are agreements only, no? అందుకు ఇచ్చినారు. Contracts అయితే initially they are enforceable, later they will become unenforceable. So void contract ఇచ్చినారు. Agreements means from the beginning they are not enforceable by law. Okay? Initial impossibility and supervening impossibility. If it is supervening impossibility, contract becomes void. If it is an initial impossibility, from the beginning agreement is void. Clear? So there is a difference between void agreement and void contract. Void agreement means from the beginning it is void. Void contract means initially it is valid only, but at a future date it becomes void. Why illegal contracts is given? Initially at the time of entering into the contract, it is a lawful contract only. India-China example. India declared war against China. Okay, all the agreements or contracts entered with India, China before declaration of war becomes illegal now. Clear? Your good name? Sakshi. Stand up. For suppose you invited all your friends for a party at your house. Then may be valid also means all secondary agreements connected to the void agreements may not be invalid. Some agreements may be valid. The theater example I explained, no? That's it. But if any connected agreement is there to a illegal agreement, all such connected agreements or secondary agreements becomes illegal and void. Clear? Gautam agreed to buy a diamond necklace for his wife. Okay, social and domestic agreement or not? Valid or void? As he is financially struggling, he decided to rob a bank with Vaishnavi. Collateral agreement or not? Void or valid or void? It may be valid, it may be void. Clear? Why Darahasini is not coming? Finally, I remembered a name. Correct only, no? Aipenda? No difficulty, right? Easy only. Tulasi? అర్థమైందా నాన్న? అవునా? Shall we move to the next topic? Yes or no? Next topic is, my dear students. Sure. Okay, you finish your talking, then I'll start. I'll wait for. Shall we continue? అయిపోయిందా మాట్లాడడం? అయిపోయిందా? So now we'll discuss essential elements of a valid offer. Essential elements of a valid offer. Write down essential elements of a valid offer. Heading, write down essential elements of a valid offer. Thank God. Thank you. First point, write down. Offer must be capable of creating legal relation. You are not supposed to write any explanations. Just write that particular point. Under essentials of a valid offer, write down point number 1. Offer must be capable of creating legal relationship. Offer must be capable of creating legal relationship. Tulasi, stand up. Offer in a social agreement creates legal relationship or not? Offer in a social agreement. Offer in a commercial agreement. Offer in a legal agreement. Offer in a political agreement. Offer in a domestic agreement. Offer in a illegal agreement. That is the point. If the offer is given in a commercial agreement, the offer is capable of creating legal relationship between the parties. If the offer is given in a social and domestic agreement, it cannot create any legal relationship between the parties. No confusion? Simple. Second point, write down. Point number 2. Offer must be certain, definite and not vague or unambiguous. Wait. Point number 2. Offer must be certain, definite and not vague or unambiguous. Highlighted point. Write down. Point number 2. Means second essential element. Rasara, I am giving an offer to Vaishnavi. Vaishnavi, I want to sell my water bottle to you. Valid offer or not? Yes or no? Yes. Am I mentioning the price? Valid offer or not? The offer creating confusion or not? Ambiguity is created or not? Meaning must be certain or not in a contract or in an offer? So, what is given here? Second essential element. Offer must be certain, definite and not vague or unambiguous. Means what? Must not create any confusion. It must be certain and definite. I want to sell my water bottle to you for 250 rupees. Valid offer or not? Because the meaning is certain and definite. It is not creating any confusion. Clear? Third point, write down. Offer may be expressed or implied. Anushka, explain the point. Express offer is also a valid offer. Implied offer is also a valid offer. Sit down. That's it. Offer may be express or implied. Offer given by words spoken, valid or not? Offer given in writing, valid or not? Offer given by the conduct of the parties or behavior of the parties, valid or not? So offer may be express or implied. Clear? Write down the next point. Any doubt? Any doubt? No? Offer may be specific or general. This I will explain while discussing types of offers. Types of offers. Next point, write down. Offer must be communicated. Rasara? I wanted to sell my car to Sakshi for 50 lakh rupees. Okay, what I am supposed to do? I have to communicate the same to her. I have to make a phone call and I have to say like, Sakshi, I wanted to sell my car to you for 50 lakh rupees. Without communicating whether she'll come to know about my offer or not. She'll not come to know about my offer. So she cannot accept the same if it is not communicated. So communication of offer is very important. Whenever an offer is given, it must be properly communicated to the other party. Then only it becomes a valid offer. No confusion? Write down the next point. Next essential element. Janvi explain. Who gives offer? Who will accept? While giving offer, with what intention offerer will give an offer? To get the acceptance. Offerer gives offer with an intention of getting acceptance from the other party. That is the point. Offer must be given with an intention to get the acceptance from the other party. Otherwise, it is not a valid offer. No confusion? Next point. Offer may be conditional. Write down, I'll explain. Offer may be conditional. Let me give you an example. Vaishnavi is having an independent house. Vaishnavi is having a independent house. In that particular house, 3 portions are there. 3 portions are there. Gautam wanted to become her tenant. Gautam wanted to become her tenant. Went to Vaishnavi. Her house is located in Hyderabad only. I went to her and said, Vaishnavi, I want to take 1 portion on rent in your house, I said. What she replied like, Gautam sir, you can become my tenant. Okay, monthly rent is 20,000 rupees. But you have to deposit 20,000 rupees in advance. Apart from the rent, as a security deposit, you have to give 20,000 rupees to me. Then only you can become a tenant in my house, she said. Okay. Now, she is giving an offer. Yes or no? She said, Gautam sir, you can become a tenant in my house, provided you should deposit 20,000 rupees as a security deposit. You should give 20,000 rupees as a security deposit. Before giving an offer, she is putting a condition or not? To become her tenant, what should I do? First I should deposit 20,000 rupees. Then only I can accept her offer. Yes or no? So, in some cases, my dear students, offer may be conditional. There may be conditions in a offer. To accept the offer, acceptor must fulfill all those conditions. Then only acceptor can accept the offer. Clear? Offer may be conditional. Ardhamainda? Tanushka. What is the next point? Don't write this, I'll dictate, write. Offer must not contain any negative terms in it. Offer must not contain any negative terms in it. What does it mean? Let me give you an example, you will understand. Okay? I wanted to sell my car to Vaishnavi for 50 lakh rupees. Who is giving offer? Who should accept? What I am saying to Vaishnavi, Vaishnavi, give your acceptance within 3 days. Otherwise, I will take your silence as acceptance. Otherwise, I will take your silence as acceptance. This is a negative term or not? Offerer cannot take acceptor silence as acceptance. Acceptor must give her acceptance. If this negative term is there, it is a valid offer or not a valid offer? That is the meaning. While giving an offer, offer must not contain any negative terms in it. No confusion? What is the next point? Offer must be distinguished from? Write down this point, I will explain. This one, write down these 2 points. Offer must be distinguished from a declaration or mere statement of intention. Let me give you an example. Gautam is saying to Santosh, Santosh, I am thinking to sell my property for 25 lakh rupees. Here, am I giving an offer or am I making a statement? Yes or no? I'll take this example only in a different way. Santosh, I want to sell my property to you for 25 lakh rupees. Here I am giving an offer or making a statement? I am giving an offer. In the previous case, I am making a statement. So that is the point. Making a statement is not giving an offer. Offer is different, making a statement is different. Offer is different, showing my intention is different. I am thinking of selling my property. Am I showing my intention or directly giving an offer? I am just showing my intention. That is the point. Giving an offer is different, showing intention is different. Giving an offer is different, making a statement is different. Is that clear? Next point, write down. This point, write down. Offer must be distinguished from mere communication of information in the course of negotiation. Case law names are given, no? Here it is given, you have to write down. Types of offer we'll discuss. Okay? Here also you have to write down. Name of the case law you have to write down. No need to write the explanation. Just write down the name of the case law. What has happened in this case law? Harris versus Nixon. It's Nickerson. Harris versus Nickerson. What happened? A newspaper advertisement is given for conducting an auction. A newspaper advertisement is given for conducting an auction. Auction cancelled. Can you file a case on the other party? Because giving an advertisement is not an offer. Giving an advertisement is not offer. It is just showing intention. Just showing intention or making a statement. We are thinking to conduct auction on these particular dates. Is this an offer given or advertisement? Advertisement means a statement made or offer given? Statement made. Different from offer given. Yes or no? What is the second point you wrote? Mere communication of information in the course of negotiation. I am having a stationery shop. Okay, Gautam is having a stationery shop. So Vaishnavi visited my shop. Vaishnavi visited my shop. She saw a particular pen and asked for the price of the pen. Asked for the price of the pen. I said, cost of this particular pen is 500 rupees. How much? What I said? Cost of this particular pen is 500 rupees. Am I giving an offer or just passing information? Communication of information, my dear students, is different from giving an offer. Communication of information is different from giving an offer. I want to sell this pen to Vaishnavi for 500 rupees. Communication of information or offer is given. I want to sell this pen to Vaishnavi for 500 rupees. Offer is given or information is communicated? Offer is given. Cost of this particular pen is 500 rupees. Gautam said to Vaishnavi. Offer is given or just information is communicated? Communication of information is different. Giving an offer is different. Both are not same. Famous case law is Harvey versus Facey. Harvey versus Facey. Wait. What is the name of the case law? Harvey versus Facey. Hi. What is happening here? Facey is writing a letter to Harvey. What he is writing? Wait. This is. Here, Harvey is writing a letter to Facey. What he is saying? Telegraph, lowest cash price. He is inquiring for the price of a pen. Yes or no? Who is inquiring? Harvey through a email inquiring for the price of a pen. Bumper Hall pen. What is the pen? Bumper Hall pen. What Facey said? The lowest price for the bumper hall pen is 900 pounds. Here, Facey is giving an offer to Harvey or just communicating information to Harvey? Just communicating information to Harvey. Wait. Facey is asking to sell the pen. Harvey is asking Facey to sell the pen. Harvey is asking Facey to sell the pen. Who is the buyer? Harvey. Who is the seller? Facey. Who inquired first? Harvey. Who communicated the information? Facey. Facey is giving an offer or just communicating information? Communicating information. Harvey took it as an offer only. Harvey took it as an offer only and asked Facey to sell the pen for 900 pounds only. Facey declined. Facey said no, saying that I have not given any offer, my dear. I just communicated information saying that lowest price for the pen is 900 pounds. I am not going to sell any pen for 900 pounds. Who will become angry? Harvey becomes angry. Files a case in the court of law. Files a case in the court of law. Trial court is like a district court. Who wins there? Facey wins. Harvey loses and Facey wins. Then goes to appellate court. Who wins there? Next goes to Supreme Court of Jamaica. Who wins? Next goes to Privy Council. Privy Council is the apex court in that particular country. According to your opinion, who should win? Harvey or Facey? Facey only will win. Why? Because Facey has not given any offer. Facey just communicated some information to Harvey. Harvey cannot take it as a offer. Harvey cannot take it as a offer. Clear? No confusion? So what is the judgment given? This is the Privy Council. We'll see. No. So, what was the judgment given, my dear students? Facey wins the case. Facey need not to sell the pen to Harvey because Facey is not giving any offer to Harvey. Facey is just communicating information about the price of the pen to Harvey. That is what Harvey versus Facey case law. This case law is also known as bumper hall pen case law. What is it? Bumper hall pen case law. Am I clear? So, offer is different from passing a statement. Offer is different from communication of information. Offer is different from showing intention. Is that clear? Yes. No confusion, no? Santosh, ardhamainda? What is the next point? Write down offer is distinguished from invitation to offer. Offer is distinguished from invitation to offer. Let him come. Sit down. జంటలు కట్టుకుని కూడా ఎందుకు సార్ నాకు అర్థం Offer is distinguished from invitation to offer. To know this provision, my dear students, you have to know the difference between offer and invitation to offer. Let me take an example. Gautam is having a jewelry shop. Gautam is having a jewelry shop. In glass boxes, to attract customers, Gautam displayed all the jewelry models in his particular shop. Okay? By seeing the jewelry models, Tanushka visited Gautam's jewelry shop. Tanushka visited Gautam's jewelry shop and asked for a particular diamond necklace. I wanted to buy this diamond necklace. Shopkeeper said, stock is not available. I cannot sell this diamond necklace to you. Here, who is giving offer and who is accepting? Gautam is giving offer or Tanushka is giving offer? Who is the shopkeeper? Who is the customer? Who is giving offer? Who should accept? Here, Tanushka visits the shop, yes or no? She will inquire, she will ask for the diamond necklace, yes or no? I want to buy this diamond necklace. Here, Tanushka is giving an offer to Gautam or not? If the stock is available, if the diamond necklace is available with Gautam, Gautam will accept the offer or not? Gautam will sell the diamond necklace or not? Now say who is giving offer? Who is accepting? But who is inviting the customer? Who is giving invitation to offer? So, Gautam, by displaying goods in his shop, is not giving offer. He is giving invitation to offer. Offer is given by Tanushka, accepted by Gautam. If the stock is not available, Gautam can reject the offer also. Yes or no? If the stock is available, I will accept. If not, I will reject the offer. But by displaying the goods in the shop, by displaying the jewelry in the shop, am I giving an offer or am I giving an invitation to offer? Invitation to offer. Got the difference between offer and invitation to offer? Giving an offer is different and giving invitation to offer is different. Sir, why this invitation to offer concept is included here? Just to explain about a shopkeeper displaying jewelry in his particular shop? No. The purpose is different. You know about companies, no? Companies issue shares, right? To whom? To shareholders. Public who buys shares are known as shareholders or not? So, companies issues shares to the public. What is the purpose? To collect investment for the purpose of carrying on their business. Yes or no? Gautam is having a company, VGR Limited. It is a public company only. Gautam can issue shares or not? Yes or no? Yes. Public companies can issue shares to the public to collect money from the public. For suppose, investment needed by Gautam to start a business is 10 rupees. How much? Gautam is having not even a single rupee. Gautam is having not even a single rupee. Gautam came to the class. There are 10 students in the class. Gautam said to all the 10 students, my dear students, to start a business, I need investment of 10 rupees. How much? 10 rupees. Give me 10 rupees. I asked Vaishnavi only. Vaishnavi, give me 10 rupees. I'll carry on a business. I'll earn profits. Then I'll give a share in my profits to you, I said. What Vaishnavi replied? Sir, I alone is not having 10 rupees. But there are 10 students in my class. In our class, there are 10 students including me. Each one is having 1 rupee. Each one will invest 1 rupee in your company. You should pay, you should give profits to 10 of us if you earn profits. I said, okay. What I am doing? I am dividing 10 rupees into 10 equal parts. Each part is a share. Each part is a share. Total amount is how much? Share capital. What is the share capital? Total amount. How much? 10 rupees. 10 rupees is the share capital. Total share capital is 10 rupees. Total share capital is divided into 10 equal shares of 1 rupee each. Of 1 rupee each. So, am I collecting money from my students or not? Without knowing about the company, can you invest your money in a company? Without knowing about a college, can you join in a college blindly? Stand up. What is the difference between a contract and an agreement? Contract? Wrong. Stand up for a while. Not correct. Your answer is not correct. Okay? So what we are discussing, without knowing about a particular educational institution, will you join? How will you know about the college or educational institution? You will go through the brochure, pamphlet issued by that particular college. What it contains? Infrastructure facilities, faculties, their experience, courses offered by the college, locations or branches. All these information will be contained in the brochure or not. After going through the brochure only, you will decide whether to join in that particular college or not. Yes or no? Likewise, before investing in a company also, you have to go through a particular document. What is it? It is known as a prospectus. It is known as a prospectus. You might have studied in your intermediate commerce. Prospectus. In companies, company issues prospectus. Commerce students only know. Company issues prospectus to attract shareholders, to attract investment, money into the company. Yes or no? So, company issues prospectus with the, sit down, with the details containing assets of the company, liabilities of the company, ventures carried on by the company, managers of the company and directors of the company. With all this information, Janvi, stand up. With all this information, company issues a prospectus. Okay? After going through all this information, investor will decide whether to invest in the company or not. Okay? Now, before selling shares, company is issuing prospectus or not? Company issuing prospectus for attracting shareholders is not an offer given by the company. It is an invitation to offer. If the investor likes the prospectus, investor decides to buy a share in the company. Who is giving offer? Investor only will go to the company and will give an offer. Sir, I want to buy certain shares in your company. If the shares are available with the company, company will accept the offer. Otherwise, reject. Okay, application will be rejected. This is the purpose, sit down. This is the purpose why invitation to offer provision is added to the act. Okay, conclusion is company issuing prospectus to attract shareholders is not an offer given by the company, it is an invitation to offer. Giving an offer is different, and invitation to offer is, no confusion? No? Offer is distinguished from invitation to offer. Offer is distinguished from communication of information. Offer is distinguished from passing a statement. Offer is distinguished from showing our intention. Clear? No confusion, right? In all these points, very important in the examination point of view. Right? Moving to the next topic, my dear students, types of offer. Write down, heading write down types of offer. What is the time now? 3:40, 20 minutes is there, no?
College is only up to 5.
3:30 to 5 another class is there. I got information like I have to take from 2 to 4. That is the reason I am continuing. Okay? Shall we? We'll listen. We'll complete types of offers. Okay? How many types of offers? Wait. What is the first type of offer? You only say what is an express offer? No need to take my permission. Me only said no need. What is express offer? What is express contract? Contract entered by word spoken or written agreements is a express contract. What is an express offer? Offer given by word spoken or in written agreements is known as express offer. What is implied offer? Offer given by behavior of the parties or conduct of the parties is known as implied offer. Right? What is the general offer? Listen. Offer given to a particular individual is a specific offer. Gautam wanted to sell his car to Vaishnavi for 50 lakh rupees. I am giving an offer to a specific person or not? This is a specific offer. Amazon company announced Big Billion Day sale to a large number of public or to a particular individual. This is known as a general offer. When an offer is given to the general public, it is a general offer. When an offer is given to a particular individual, it is a specific offer. No confusion? Coming to cross. Tulasi, what is a cross offer? What is a cross offer? I have not explained yet. What is a general offer? Offer given to a particular individual is a specific offer. Gautam is entering into a contract. Gautam is giving an offer to Rishita to sell his car for 50 lakh rupees. General offer or specific offer? I am giving an offer to a specific person. Okay, I am offering chocolates to all my students. General offer or specific offer? When an offer is given to the general public, to the public at large, it is a general offer. When an offer is given to a particular individual, particular single individual, it is a specific offer. Sit down. What is an express offer? Offer given in word spoken or written agreements is a express offer. What is an implied offer? Offer given by the conduct of the parties or behavior of the parties is implied offer. General offer and specific offer is also done, no? Coming to cross offer. Listen carefully. When same offer is exchanged by both the parties in ignorance, when identical offers or same offers has been exchanged between two parties in ignorance, it is known as cross offer. I am making a phone call to Vaishnavi. started saying, Vaishnavi, can you buy my car for 50 lakh rupees? Due to a signal problem, she is unable to hear properly and replied, Gautam sir, can you sell your car to me for 50 lakh rupees? Both the parties are making offers only. The same offer is exchanged between two parties in ignorance. Yes or no? This is known as cross offer. What is it? Cross offer. What is the last type of offer? When the original offer is modified by the acceptor, it is known as a counter offer. I wanted to sell my car to Vaishnavi for 50 lakh rupees. Who is giving offer? To whom? Who should accept? Instead of accepting, Vaishnavi said, Gautam sir, I will buy your car, but for 40 lakh rupees only, not for 50 lakh rupees. Acceptor is modifying the original offer or not? Original offer is given for how much? Who is modifying? Acceptor or offerer? When the offer is modified by the acceptor, it becomes a counter offer. In counter offer, acceptor becomes offerer again. Offerer becomes acceptor again. I will buy your car for 40 lakh rupees only. Offer is given by Vaishnavi again. Gautam should decide whether to accept or not. In counter offer, offerer becomes acceptor, acceptor becomes offerer. What is the counter offer? When the original offer is modified by the acceptor, it becomes a counter offer. No confusion? This is all about types of offers. Specific offer, general offer, cross offer, counter offer, express offer, implied offer, and one more offer is there. It is open offer or standing offer. Standing or open offer. When an offer stands for a particular period of time, it is known as open offer or standing offer. Let me give you an example. Amazon Big Billion Day sale. Sale valid from 1st January to 21st January. Okay. Offer is open from 1st January to 21st January. Such type of offers are known as standing offers or open offers. Write down types of offers. Express offer, types of offers. What is the first type of offer? Express offer. Point number 2, write down. Implied offer. Express offer. Implied offer. Point number 3, general offer. Write down the case law name. One is express offer, 2 is implied offer, 3 is general offer. 8. Implied offer, 3 is general offer, given here, see. Where did it go? Write down, I will dictate. Express offer, implied offer, general offer, then specific offer, then cross offer, then counter offer, standing or open offer. Last one is standing offer or open offer. General offer and specific offer, write down the names of the case laws. Given in the box C. General offer and specific offer, write down the names of the case law. Is that clear? about types of offers? No confusion, right? We'll conclude for today. We'll continue in the next class. Thank you. నేను అడిగాను శ్వేత మేడంని 4 వరకు తీసుకోండి అని చెప్పారు. I don't know that. So sorry. No doubts in today's class, no? Easy only.